Good day to all our viewers. Welcome back to another What If session. My name is VP and today's topic is what if a dismissed employee wants to settle the matter? Majority of employers, if not all, have been taken to the CCMA or Bargaining Council. We know that all disputes referred to the CCMA or Bargaining Council must be conciliated, and during this conciliation, the conciliating commissioner or conciliator will ask the employer whether they are willing to settle the dispute. The question thus is, when should you settle a matter? Now, to answer this, we need to consider the following. One is the outcome requested by the employee in the referral form, if that part of the referral form has been completed. Does the employee seek compensation, or does the employee seek reinstatement or reemployment? Second consideration is whether the other party has suggested talks prior to the conciliation, specifically settlement talks, obviously. The third consideration is your prospects of success as the employer and the merits of your case. The fourth consideration is the CCMA's powers, or at least discretionary powers, in awarding compensation, right? Yes, we know it's capped at a maximum of 12 months for normal unfair dismissals. But what is this? What is the average payout? What can we expect that the CCMA will award in the case of an unfair dismissal? The fifth consideration is your alternatives and or best possible alternative in the event that there's no settlement. And then finally, probably one of the most important considerations is the cost implications or implication should you proceed to arbitration. Inconvenience, obviously traveling costs, asking a witness to be absent from work for 3, 4, 5, maybe even 2, 3, 4 days. Your legal fees, if that is applicable, flight costs, petrol, parking, all of those things add up. So that's a very important consideration. However, let's focus on the first one, the outcome requested by the other party. Now, in any case, it's obvious that you will assess your prospects and the merits of your case. In other words, you must assess and or evaluate your case, whether you obtain legal advice or not, and you must determine whether the dismissal could be substantively unfair, or maybe procedurally unfair, or maybe even both. Right. Now, as soon as you have done that and it transpires that the dismissal could be substantively unfair and the employee has requested in the referral form that he or she seeks compensation, then you need to know that in all likelihood, with the substantively unfair dismissal, the commissioner may award a reinstatement. Reinstatement and reemployment is the primary remedy that can be awarded to employees. Further to that, if a dismissal is substantively unfair and the commissioner does not award a reinstatement, we are probably looking at anything between 1 and 8 months compensation. So, 1, you don't want an employee that you've dismissed back at the workplace, and 2, you definitely don't want to pay 8 months compensation for an employee whose dismissal is deemed to be substantively unfair. The point is that if you have concluded that there is a possibility that this dismissal of the employee is substantively unfair, or maybe even substantively and procedurally unfair, 1, the risk is there that the employee may be reinstated, and 2, the average compensation awarded over in terms of such an unfair dismissal case is anything between 1 and 8 months. So reach out to the employee if he or she requests compensation, ascertain what it is that they seek as settlement if it's not clear on the referral form, and then make the decision. If the employee wants 3 months, we are in for maybe a reinstatement, or we are in for possibly 8 months, then we can offer 1 month or 2 months as settlement. If the dismissal is, well, at least if you determine that the dismissal could be procedurally unfair but substantively fair, then we need to know that the reinstatement is off the table. In other words, a commissioner can only award reinstatement if the dismissal is substantively unfair. If it's only procedurally unfair, the commissioner can only award compensation. In such a case, the compensation, again, I believe the average is about 6 weeks, but you can probably work with anything between 6 weeks and 4 months. So again, the employee requests compensation on the referral form. You should reach out, determine how much, what it is exactly that the employee seeks. If the employee says, I want 1 month or 2 months compensation, genuine consideration should be given to settling the matter, because it is less than what the CCMA is likely to award. Now again, ladies and gentlemen, the assumption here is that you have assessed the merits of the case, your prospects, and you conclude that the dismissal could be substantively or procedurally unfair. If you have prospects, it's a different story, and we'll discuss it in a minute. The second consideration is whether the other party has suggested settlement talks. Now, if someone reaches out to you, or the applicant or the applicant's representative reaches out to you, do not necessarily just close the door, rather consider settling the matter. Why is that? Because it may indicate the fact that this applicant or the representative is reaching out first, that there's a genuine desire to settle the matter on their part. Right. Third point is prospects of success and the merits of the case. So in the event that you evaluate your own case, you can obtain legal advice in this regard or not, and you find that you do not have prospects nor merits, it is advisable that you consider settlement. Even if you have prospects, when we talk about costs in a minute, even when you have prospects of success, it's always best practice to consider the costs, or the cost implication at least, in determining whether to settle or not. The next consideration is the CCMA's discretion in awarding compensation. We've mentioned earlier the average amounts that you can expect. If it is a case of procedurally unfair dismissal, then we know the CCMA may award anything up to 12 months, but on average we're looking at 6 weeks to about 2 months. If it's substantive unfair dismissal, then we're looking probably at anything between 2 to 8 months. Automatically unfair dismissals, we know the maximum compensation is up to 24 months. The next item is the cost implication. Now, should the matter proceed to arbitration or even the labor court, we know that there is costs involved. Costs relate to preparation time in terms of legal fees, the time that your witnesses need to spend at the CCMA, all of this add up, petrol, flight costs, all of that, it does add up. What you should do is you should consider the amount, or the total amount that the case may cost you in terms of your disbursements, legal fees, etc. If the employee, and that amount comes to, let's say, 20 or 30 or 40,000 rand, if the employee wants 5,000 rand, even if you have prospects of success, it would be advisable, it would be, the best approach would be to settle the matter on the basis that it is simply cost effective. Now, if you look at the advantages of reaching a settlement, time is the first item that I can think of. It will definitely save time to settle the matter, and it ultimately resolves the dispute in an expeditious manner. We know that when a matter is settled, it's in full and final settlement. The employee may try to bring back the matter later on, but the settlement is in full and final settlement. The value is another advantage of settling the disputes, or settling disputes, because settling at conciliation makes for a win-win situation. In settlement, one avoids a long drawn-out dispute. Again, from a mediation or conciliation point of view, the idea at conciliation and the reason for settling is because at that point in time, the process is still in your hands. As soon as it goes to arbitration, there's a third party who's going to decide whether the dismissal was fair or unfair. If it's unfair, it's no longer in your hands, and that arbitration award is made and the relief is awarded, the remedies is awarded, whether it's compensation or reinstatement. The third advantage, we've mentioned this, is from a cost point of view. There's no doubt that it is cost effective to settle matters. Should a matter proceed to an arbitration state, cost can include your preparation time and the expenses involved there. Legal fees, if any, and this should obviously also include subsequent litigation. We know after the CCMA matter can be taken on review to the Labour Court, which is quite expensive. The time you spent at conciliation versus the arbitration, it's obviously, as I've mentioned, much quicker to be at conciliation. That would be half an hour to an hour, when arbitration can be hours, days, even weeks. Maybe you need to prepare transcripts for the arbitration. There's costs involved. Time costs, so wages, productivity, all those losses for the management and the witnesses that need to be there. And then obviously finally, and the economic costs if the award goes against you, in terms of compensation or reinstatement, and even sometimes reinstatement. Most of the times I would say reinstatement is with a retrospective effect, so there would be back pay. Ladies and gentlemen, I hope that you have found this information useful and that you can apply it at your next conciliation. This then brings us to the end of this video. This then also brings us to the end of What Ifs for 2020. As always, we thank you for watching. From all of us at Maserumule, we hope you have a blessed festive season, and we wish you all the best for 2021. Please stay safe, and until next time, bye-bye.